Good afternoon, everyone. We're just waiting for everyone to come in. All right. Thank you so much for joining us. Good afternoon. I'm Kayla Henderson. I'm an attorney and pro bono coordinator at Inland County's Legal Services, or ICLS, as some of you know us. ICLS is a 501c3 nonprofit legal aid organization serving Riverside and San Bernardino counties. This is our last informational webinar of our summer series. Today, our webinar will be covering common employment pitfalls and the very real and potentially expensive consequences. If you have any questions throughout the webinar, please feel free to put them in the chat and we can address your questions at the end of the presentation. Our presenter today is Ed Langhammer with the law firm Cozen O'Connor. Ed has over 35 years experience representing clients in all aspects of employment law and related litigation. Ed represents corporate and business organizations as well as nonprofit and charitable entities. And just so you are aware, our small business clinic offers one-on-one consultations for eligible small business owners on a variety of topics, including employment law and entity selection or business structure selection. So if you're interested in applying for our services, you can contact myself or my colleague, Matt Kugazaki, directly, and we'll be putting our emails in the chat. So with that, I will hand it off to Ed.
Thanks, Kayla. I appreciate it. And hi, everybody. Hopefully you all can hear me okay. So yes, we're talking about small business essentials, just some common employment pitfalls and very real and expensive consequences. So this is basically our disclaimer, folks. We're here to give you general information. We can't respond specifically to specific questions you have, which would involve the attorney-client work product privilege. So so if you want to ask questions, please do. We'll have time at the end for this. But just remember, you can ask me very specific questions about the operations of your particular company and specific employees and so forth, because I won't be able to answer that. Besides, there's no attorney-client privilege. We're recording this, so you don't want to ask me those questions. But the good news is, as Kayla just mentioned, is if you need services after the fact, ICLS has resources available. Let's say it that way. So we're a big law firm. I'm in the Santa Monica, California office. There's about, I don't know, 825 or so of us. There's about 80 of us in the employment department. So we cover a lot of different territory. And as Kayla mentioned, making me feel really old, I've been doing this stuff for a long, long time. So that's me. And today, this is what we're going to cover. And every single one of these things is a potential pitfall, which has expensive consequences, potentially. So we're going to have to rip through this pretty fast because we've got a lot of slides. I'm not going to cover everything verbatim. I'm not going to read to you. But the good news is you're going to get a copy of the slides afterwards. So don't be worried because you're going to have that information. We're going to talk about size of the company. Size of your company matters. We'll talk about why that matters. We're going to talk about hiring compliance, wage and hour compliance, huge issue in my world, huge issue for many companies trying to be compliant with the laws. Discrimination, harassment compliance that hadn't gone away. That's still a big issue. Termination compliance. I'll talk a little bit about new laws on the horizon. And then as we go through the program, we'll try to cover some best practices. So let's get right into it. So why does the size matter? Well, it's because there's some California and federal baselines that we talk about. So if you only have one employee, and I know many of you are small employers, you're just starting out, congratulations. Hopefully you're going to grow. But this is why we want you to be mindful of different laws kick in and apply depending on how big you are. So if you just have one employee, you plus someone else, then you have to comply with it, and there's possible liability that attaches to the California and federal wage and hour laws, mostly California, sexual harassment, COVID-19 safety in the workplace, with some exceptions we're not going to get into, paid family leave, paid sick leave, insurances that are required by law, state disability, unemployment, workers' comp insurance. And if you have 5 or more employees, you have to comply with all of the above plus discrimination, harassment, laws. And if you have 15 or more, then it's all of the above. Plus, you've got to comply with some federal laws, and you've got to comply with discrimination, retaliation, and harassment laws. And if you have more than 15, then as you get bigger, then different laws will kick in. For example, under federal law, for the family medical leave, federal family and medical leave to apply to you, you need to have 50 or more employees working within a 75-mile radius, and there's other factors. So we're just giving this information to you to illustrate why the size of your company matters and to be mindful as things change. You continue to, look at this stuff and decide, are there other laws that may apply to me? These are just some of the laws that are going to apply. Title VII of the Civil Rights Act, the Pregnancy Disability Discrimination Act, the Americans with Disabilities Acts, age discrimination, USERRA, Family Medical Leave Act. In California, we've got the Fair Employment and Housing Act, we've got the Family Rights Act, we've got pregnancy disability leave laws, and we've got other miscellaneous leaves, including things like school matters, organ donors, crime victims. So we got a lot of laws. So again, as far as best practices, be mindful of these various laws that are going to kick in. Um, Things will change over time for you. Hopefully, you'll grow. Maybe you'll contract, but in any event, you just need to be mindful. And we always recommend training for those decision makers and managers. It's a never ending process. As we know, as I mentioned, I've been doing this for a long time. When I started practicing law, a lot of this stuff didn't even exist. So the law has continued to evolve. It's California is a tough place for us to do business for our companies, and so there's lots of places where you can go wrong. So let's talk a little bit about hiring. So here in California, we have this doctrine called employment at will. And that means real simple that at any point in the relationship, you can say, hey, look, things aren't working out. We're gonna go ahead and fire you. And at any point along the way, an employee can say, hey, things are not working out. I'm gonna go ahead and quit. And it doesn't have to be with a reason, doesn't have to be with cause. But so people think, well, it's at will, so I can hire and fire whenever I want to. Well, you can, except the thing is, as presumptions to that will doctrine, you have to be mindful that you're not doing things like committing statutory violations, terminating someone for an illegal reason, race, sex, color, creed, gender, orientation. There's 18 or 20 categories right now that you're not retaliating against people, that you're not violating a public policy. And if you have an oral written contract, hopefully, if you have a contract that's in writing, because we say oral contracts aren't worth the paper they're written on. So if you do have a written contract, that could trump the at will relationship. And you always have to avoid bias. It just goes without being said that in the workplace, you have to ask it for information that's related to the job, that's not far afield, that's not, impermissible to ask. And you could be liable for discrimination, whether or not the information is unlawfully solicited or volunteered. So here we've got on the next slide just some examples. I'm not going to read them to you, because you're going to have these slides. But there's just sort of some lists of acceptable things you can ask, and then some unacceptable things you can ask. And so you just have to be mindful that you need to use neutral terms, that are not tied to a specific protected characteristic. And some questions can be a little slippery slopes. Some of it's in the way you phrase it. So we're giving you some examples of that. Again, there's what other things can you ask, and do's and don'ts. Well, California now has this thing called a salary history ban. So that means you can consider or rely on information that's voluntarily disclosed, but and you can ask about what do you expect to get paid, but you have to provide a pay scale for employees at the employee's request. And if you have more than 15 employees and different requirements, you have to include that pay scale and job postings, and you have to maintain records. So you have to be careful that you're not asking, to specific information about a salary history and seeking that information. And you have to provide applicants with a completed initial interview with the pay scale. And again, there's some other ban the box. There's certain criminal convictions that you can't ask about, or if you find out about them, then you have to make sure you go through the process. We'll talk about that a little bit more. And the other thing I always say is, if you use an employment application, you need to do the best you can to make sure it's compliant. And what do I mean by that? Well, sometimes you can go online and you can download a form. Sometimes it's free, sometimes you pay for it. But you have to be mindful, those may not be California specific, they may not be updated. So be careful about using those things that you may download off the internet. Um, Arrest records, you have to be careful about asking about, seeking, or using information related to arrests, things, convictions that have been sealed, expunged, eradicated in some way, non-felony marijuana convictions. Again, you'll have these slides. So so here there's just a lot of areas about do's and don'ts, cans and can'ts. So you can ask about convictions, and certainly after making a preliminary offer, a conditional offer of employment. So what do we mean by that? Well, I agree to hire you subject to satisfactory completing a background check. That's the most simple way of saying it. So there's lots of things you can, with respect to whether you make a denial, after you do a preliminary denial. So there's a whole process that you have to comply with if you're going to be obtaining this information. And then new hire notices and paperwork. This really is kind of the devil's in the details on this. And these are just standard, come away with one thing. These are just pretty standard things that you need to have provided notices and the appropriate paperwork with respect to. I'm going to back myself up just 1 second with respect to information that you're seeking. Be very careful about going online, going to social media websites, and looking to obtain information with respect to people who you are thinking about hiring, or for that matter, on your current employees, because that can be very problematic. There's issues with respect to whether people have expectations of privacy by publishing something on social media. But on the other hand, you have to be careful about what information you use and how you use it. That's subject for a whole other webinar. But I did want to mention that before we got too far away from that slide. So some of the new notices are the I-9 forms. New info, the I-9 form is being revised. I have not seen it yet. I know it may be out for public comment. It may already be out and be available, but I-9 is required in order to make sure people are eligible to work in this country. And there's a new one coming out. You have to make sure you fill out do the appropriate tax forms. There's a notice to employee under the labor code that needs to be given. And then you need to give certain pamphlets and notices to employees, including the paid family leave program, workers' compensation. All companies, if you have any employees, required to have workers' compensation. So you need to be mindful of that. State disability insurance, again, it's required. It's something employees are entitled to. It actually comes out of their paychecks to fund the program. The sexual harassment information, the company's policy, rights of victims of domestic violence, sexual assault, stalking, health insurance notices, workplace posters and postings in the workplace. This is important, that you're required to have certain posters and postings up in the workplace. And there are companies out there where you can buy them from, and they're specific to the size of your company. So you can buy it if it's from a reputable company. Other compliance considerations that we'll go through very quickly. Should you use an offer letter? Well, that depends. I mean, this is subject of further discussion, but, should you use it for all employees, some employees? If you do, you need to make sure it actually says what you need it to say, that it's compliant, that you don't overpromise, and you have to be mindful of oral contracts and promises. I already mentioned that to you. You don't want to overpromise. You don't want to promise people things that you're not going to be able to deliver, or maybe you change your mind. Should you have an arbitration agreement? Again, this is the subject of the whole webinar just on that. But if you're going to have it, it's just the law is very unsettled. And the big takeaway that I tell clients and that I tell people when I do these webinars is if you have an arbitration agreement, all the costs of arbitration have to be paid by the company. And that means it can be really expensive. Because an average arbitration is going to be anywhere from $5,000 to $20,000 per day, and the company pays that. And so you have to be mindful if you're going to have something like that, that you really think about it, consult with somebody, get good information. Employee handbooks, I feel that all companies should have a company handbook. Doesn't have to be overly complicated. And again, it has to be specific to the size of your company. One size doesn't fit all. A handbook is a living document. It needs to be checked, updated from time to time. It needs to have certain mandatory provisions under California law, including a harassment policy. If you don't have a separate policy, should have an EEO policy. And then other things that are optional and recommended. So again, the one thing I will say, if you come from a bigger company and you say, great, I'm going to use the company handbook that I had before, and I'm just going to go ahead and republish it under my company's name. Well, that's terrific. But if you come to actually, it's not terrific, because if you come from a company that had 50 or 100 or 300 or 500 employees, and you adopt somebody's handbook without really thinking about it or thinking about what it means, you have now volunteered to comply with a lot of stuff, a lot of terms and conditions that maybe you don't want to comply with. So be careful, and be careful of downloading these things off the internet too, because again, you may wind up creating situations where you become a volunteer. Best practices in hiring, training. If anybody's involved in selection and recruitment, make sure they know. They have to know something about the EEO laws and the permitted areas of inquiry, what we've talked about before. You have to comply with background check laws, which is again, you need to make sure if you're going to check, you need to make sure you comply with it. You have to look for screening procedures if you're going to gather information from the internet, which I've already mentioned. If there's going to be, job-related information, arrests, convictions, bankruptcies, you've got to really access whether or not that's job-related or not, assess whether that's job-related or not. And then as far as any potential disparate impact, treating people differently on account of a protected characteristic, you need to be mindful. And then you need to complete the paperwork. And we always are going to say document, document, document. So you'll hear me talk about that a little bit more. But no matter what, you should always document. You should keep records. They don't necessarily have to be paper records anymore. They can be electronic, but there's different laws that apply, and you need to be compliant. And you need to keep these things, because if there is a problem downstream with an employee or a former employee or an applicant, you want to be able to have documents available so you can review, so you know what was actually happening concurrently. We say documents, but in lawyer speak, we're looking at evidence. And when we're looking to defend you and defend companies, we're looking to see whether or not there's adequate documentation, which we can use as evidence to help support the company's defenses. Wage and hour compliance, I mentioned before, is just a huge issue. And just to go, with the big picture overview, set the table. There's federal laws that apply. It's under the Federal Labor Standards Act, the FLSA. Then in California, we have the Labor Code, and we have these things called Industrial Commission wage orders. Wage orders are specific for your industry or your occupation. And a copy of a wage order needs to be posted in your place of business, wherever you have employees. It could be posted online if you need. if you're a virtual workplace. And this covers basically all private employers, with some exceptions. So if you're in the audience, if you're a public sector employer, not all of this would necessarily apply to you, but if you're public sector and you're doing this, you may already be aware of that. Who enforces the laws on the federal level? It's the Department of Labor, the Wage and Hour Division. And then in California, it's the Division of Labor Standards Enforcement, the DLSE. So it is possible that companies can hear from one or both agencies. They share responsibility here in California. So it's possible you could hear from one or both of these agencies. And so we've got just a lot of federal and state and local wage and hour laws. Local laws are laws that they have in cities, counties, some special districts, but mostly we're talking cities and counties. And those can actually have additional obligations on employers that we'll talk a little bit about. Like, so here's the takeaway though. Whatever law provides the best protection for employees is the law that needs to be followed in your particular jurisdiction. So what I mean by that is if the federal law is the most restrictive and it applies to your business, that's the one that must be followed. Generally, California laws are more strict for companies, more protective of employees than federal laws are. So it's generally the state law that will be more protective of employees. And then you'll have other situations where you have local laws that will kick in. For example, a lot of cities have their own minimum wage requirements. And so you'll see, and we'll talk about that on the next slide. So you'll see if there's a higher minimum wage in your particular city or locality, you need to be mindful of that. There's other local laws that apply with respect to sick pay law, lactation accommodation breaks, San Francisco, the city of Los Angeles, among others. So again, this is just an overview of the different laws that could kick in, and all of them are potential pitfalls for companies. So here's minimum wage increase. New info. Right now, it's $15.50 an hour. So as of January 1, it's just been announced within the last week or two that it's going up to $16 an hour. So that's the baseline. Companies who are hiring employees are going to need to pay them right now $15.50 an hour, effective January 1, $16 an hour. So that can be a significant amount of money for companies. So you need to be aware of that. Hopefully you already know this, or now you know, so you can make arrangements for it. We get a lot of issues with respect to exempt versus non-exempt employees. So what do I mean by that? Well, an exempt employee under the law is someone that is exempt from things like the overtime laws, meal and rest breaks. Um, so we get a lot of companies that think if they can put somebody on what they call a salary basis or an hourly salary, that those employees are going to be exempt because they're paid on a salary. That's not the law. That's not the way it works. And so you need to be mindful of that. And we're going to talk right now about, if you're going to try to classify somebody exempt, what do you need to do? What do you need to make sure of? Now, the flip side on that is someone who is non-exempt, and that employee is entitled to be overtime, entitled to be paid overtime, entitled to meal and rest breaks. So you need to be mindful of that distinction. And many employers know about meal and rest break periods. They know about overtime, and they look for this exempt status as a way of trying to avoid having to pay overtime and worrying about meal and rest breaks. So here's the thing, though, real short. If an employee is truly exempt, they have to be doing more than 50% of their task as exempt, and that's not easy. They have to fall into one of the accepted categories, and they have to exercise, among other things. The big one is discretion and independent judgment, and that's facts and circumstances, depends on your specific work environment. Um, They have to be paid, on a salary basis, which is only one component. They have to be paid a minimum salary. There's different rules for computer professionals. They have to be in these categories of professional, managerial, administrative, professional, computer professionals, inside sales, outside sales. So they have to fit into one of those buckets, and they all have very specific criteria for that. And here's the biggest issue for exempt employees that we see. They have to be paid at least twice the minimum wage. And that's where a lot of companies get hung up, because if you don't meet the minimum salary test, you can't even talk about the other stuff on whether they're truly exempt, because they will just fail as a matter of law. So right now, based on $15.50 an hour, you have to pay somebody a minimum salary of $64,480. If you don't pay that much, they're not going to be exempt. And the other thing is, if now on January 1, the law is going to go up. So it's $16 an hour. So that 64,000 is going to become a higher number. So you need to be mindful of that. Meal periods and rest breaks. Excuse me, we talked about that, but employees need to get meal breaks. Non-exempt employees need to get their meal breaks. They have to be taken, uh, if an employee works 5 hours or more, and they have to get at least 30 minutes. It doesn't have to be paid. It can be unpaid. Um, and if they work 10 hours or more, they get a second meal break. They have to be relieved of all duty. That means you can't have them working if they're taking their meal break. And rest breaks, they need 10 minutes every 4 hours or a major fraction, which is defined under the law as 3.5 or more hours. Then you need to get a 10-minute break, which is an on the clock break. And if you don't provide the meal breaks and their rest breaks, then they get 1 hour penalty pay at their regular rate of pay for every missed meal period and for one missed rest break per day. So that's a big pitfall. Companies need to be mindful of that. Overtime, real quick, under the federal law, it's 40 hours or more, over 40 hours in a week. Then you have to pay them overtime. California, we have an 8 hour a day overtime rule. So that means if an employee works over 8 hours a day, they need to be paid overtime for those hours over 8. And they have to be paid 1.5 times or 2 times the regular rate of pay for all overtime work. And regular rate of pay is complicated sometimes, but it includes not just their hourly rate, but any other compensation they get, per diems, non-discretionary bonuses and so forth. So you need to be mindful of that. And if you get it wrong, there's misclassifying employees as exempt creates exposure, class actions, PAGA lawsuits. And again, we talked about what exempt means, that you don't have to pay overtime. They're exempt from meal and rest break requirements. I apologize. I have a little tickle in my throat. So what time's compensable? It's all hours worked. And this is another place where companies sometimes can get it wrong, because it's all time that the employee is required to be on duty, whether either at the work site or in other premises, and at all times that they're permitted to work, whether they're even required to do so. In California, it's this archaic way of saying, you have to pay employees when they're subject to the control of the company, and an employee is suffered or permitted to work. And so, basically, if an employee is working and you knew or should have known they're working, then you got to compensate them for it. So, can certain amount of times be discarded? Well, employers sometimes think that there's a thing called de minimis. If they only work over a couple of minutes, a few minutes here and there, a half hour, then do I really have to pay them for that? Is that really a big deal? Well, it depends, because under the federal law, if there's just a few minutes that are involved, you may not have to pay them for that time. California is real strict. So we don't have this thing called a de minimis rule. So that means employees need to get paid for all time that they're working, even if it's just a few minutes. And Starbucks in 2018 found out the hard way. There's a case that we cited where you know, if the employees are under your control, they have to be paid. You can't say, oh, it was only a little bit of time. Off the clock work. This is where employees are not on the clock. They're non-exempt employees. They're not technically clocked in, however you do that in your company. Um, but employees now, because of this 24/7, world that we're in, will do things like check their emails, check their text messages, respond to text messages. There's lots of different variations of this. So the issue becomes, do you have to pay employees for that time? And the short answer is, yeah, they're working off the clock. That means, they're working and they're not logged, they're not clocked in, they're not, keeping track of their time maybe well. But you can't have employees working when they're not being paid. It's unfair to the employees, for one thing. They shouldn't have to work for free. But more significantly, it's a violation of the law. Not more significantly, as significantly, it's a violation of the law. So we have to make sure people know if they're not working, they shouldn't check. They shouldn't check emails. They shouldn't text messages. If they're going to be off, they should be off. And when they're working, they should be working. Vacation and PTO is another place where people can go wrong. On vacation and PTO, here's the law. California doesn't require vacation or PTO. You don't have to provide it under the law. But if you do, be careful because it becomes a vested right. And you can't have something like a lose it or use it policy. And so these rules also apply to things like if you give people floating holidays, personal time, unlimited vacation policies. I don't even want to talk about because it can be a real quagmire for companies. You got to be careful to think about it. Paid sick leave. This is not new, but we still talk about it. Even though it's been around since 2015, some companies still don't know. This applies to all companies, no matter how big or small you are. And so under California law, you have to pay employees, you have to give them paid sick time of at least 1 hour for every 30 hours worked, or you can front load 3 days of paid sick leave or 24 hours, whichever's longer. You need to be careful about checking local rules on that. And you can cap the accrual at 6 days or 48 hours, and you can limit the use of it to 24 hours, but check local rules in the cities they're in, because maybe that's different. And there's right here, there's a list of all the cities that have it, but new are being added. So be careful, always check. And have to give them an itemized statement with respect to accrued pay, should be on their check stub. It could be a separate document, maybe easier for companies to do it on their pay. And here's new for 2023. There's a new category because now you can take sick leave to care for yourself or a family member. That's traditional law. Family members defined, but now we have a thing called designated person. And that's any person identified by the employee at the time the employee requests paid sick leave to care for individuals outside of their family. So that's new. I mean, we hadn't seen that before, but it's new for 2023. Contractors, interns, and volunteers. I I understand many of you may want to use a model of having independent contractors, volunteers, interns in your workplace. And you just have to understand that these are very, very problematic things to do. That because employees are presumed under California law to be employees. And that means if they're employees, they have to be entitled to benefits like minimum wage, workers' comp, unemployment insurance, and so forth and so on. So you need to be mindful of if you're going to try to class people into a work independent contractor model, that there are very specific rules, and California is incredibly difficult. California applies a thing called the ABC test, which is it basically sets up forth some very specific criteria of if someone's truly going to be an independent contractor. And these are some of the requirements, but one of the big ones is it's the employee is just not under the direct control of the employer. I'm an independent contractor in what I do. So when you hire me, I come in and do it. I, of course, listen to you, but you don't necessarily get to dictate the terms and conditions of what I do. A plumber is a great example because if you haven't worked with lawyers, you probably get what a plumber does. A plumber is an independent contractor. They come in, you say, I got a broken toilet. They go fix your toilet. You don't try to micromanage them and tell them what they need to do to fix your toilet. You can tell them what you think's wrong with it. But so, the big difference. So you need to be mindful of that, of all of these elements. And depending on your business, and there are very specific requirements. And there's a form that's always forgotten by many companies, which is there's a specific EDD form, a DE 542, that you need to make sure you fill out for your independent contractors. And quickly on that, that's not even really an employment law form. That form was put in place because people were using the underground economy to work under the table, to not pay their child and spousal support obligations. So it was put in as a family law trying to catch people. But again, we're stuck with it because here we are in the employment world. Volunteers, got to be really careful on volunteers because it's an individual who performs service for civic, charitable, or humanitarian reasons without promise, receipt, or expectation of compensation for those services. I mean, this is the subject of another webinar, but having a volunteer, if you're in a private business, volunteers are incredibly problematic. And speaking of incredibly problematic, we turn to unpaid interns. Companies sometimes think having an unpaid intern is like a really terrific way. The intern gets experience, they don't have to be paid, but you need to really be mindful of this because the Department of Labor has issued guidance, which the state of California has adopted. This is an area that is very, very problematic because you have to evaluate if something is done incorrectly. You have to evaluate whether the internship is it for the economic benefit of the employer or for the educational benefit of the intern? That's the facts and circumstances. That's very specific. So, and there's 7 factors that are used, but here's my takeaway. If you're going to hire interns, be very careful, seek appropriate advice. Um, because this is an area where companies sometimes get it wrong. Small companies and large companies have gotten this area wrong. So, a short solution to not a short solution, but one solution, make sure they get paid at least minimum wage because that will give you some insulation. As far as best practices, you got to look at your contractor relationships. You got to audit and evaluate. You have to, avoid engaging people as independent contractors when it's really not appropriate. You have to avoid, all these elements that we've talked about. You should have a corporate policy on it. And you have to, if there's any agreements, they really have to be in writing and be compliant. Discrimination and harassment. So again, always have this mixed soup of laws that may apply. Federal law, we have the Federal Civil Rights Act. On California law, we have the Fair Employment and Housing Act. We now have the Civil Rights Department in California. It's been renamed. It used to be the Department of Fair Employment and Housing. And so now it's the Civil Rights Department. So also you have to be mindful of, of the labor code. And also you got other state and local laws and ordinances that kick in. So we've talked about just generally, I've mentioned protected characteristics. So I'm not going to read them all to you, but this is a list under federal law of protected characteristics. And, so here in California, we are way more robust in California because, we're going to include more categories than they include on the federal level. But these are protected characteristics under California law. And remember, just as indicated on the slide, if you have sex harassment, if there's a sex harassment issue, you only need to have one employee. So under California, you usually have to have 5 or more employees that I already mentioned. Under federal law, you usually have to have 15 or more. But if it's harassment, it's one employee. And now we have a new category for 2023. So there's another new update. We have a reproductive healthcare decision making. And that includes, but it's not limited to use or access a particular drug, device, product, or medical service for reproductive health. I am not going to get into the political issues on that. I am not going to get into the social issues. But if you read the papers, this stuff is all going on all over the country. And so California is now seeking to provide that additional layer of protection. Who's protected? Regular employees, temporary applicants, independent contractors, men, women, LGBTQ. So there's just some key terms there. I'm not going to go over them, but there are different ways of describing some of the key terms that we will see and we will come up. Hostile hostile work environment harassment. Easy for me to say. It's unwelcome conduct. It's objective. It's not subjective. It's what's the intent of the harasser's motivation? Is it severe or pervasive? These are areas where companies often wind up getting sued. And so you need to be mindful of having in place, well, we'll talk about that in a second. But you have to be careful. There are things that don't necessarily rise to harassment. If it's isolated, it's not sporadic, asking for a date, consensual welcome. Those are all things that, that may not be harassment. Who's liable? Well, you know, companies can be liable, and non-supervisory personnel can be held personally liable. Let me say that again. If you're accused of being a sexual harasser in your workplace, you can be personally liable to the person who is harassed for their damages. And that's a big issue. That's not a pleasant conversation to have to go home and explain to your family. I'm not saying this to frighten you. I'm just saying this to alert you, because for pitfalls, this is one of the areas that we do see. So it, can occur at work, but also can occur at, other company sponsored offsite events, holiday parties, retreats. There's a whole webinar we could give on, what happens if you have an offsite, what you should do. So here's some key takeaways. The harasser's motive is not relevant, either is a victim's motive. The goal is to stop the behavior. So if you see something, say something, get involved, stop it. That's the best ways. People who are in the same protected category can create hostile environments for others. That's frequently misunderstood, because people think, well, if we're the same, how can it be harassment? It can. Do good intentions count for anything? No. So here's a sample of a no harassment policy, just that we give you for discussion. It's, again, remember, one size doesn't fit all. We're giving you this for illustrative purposes to see what one may look like. But again, if you're going to use this, you're going to adopt it, you may want to seek some advice. If you're a company with 5 or more employees, you need to do harassment training. 2 hours for supervisors every 2 years, 1 hour for non-supervisors every 2 years. Training records have to be kept. And there's cool resources online. The DFEH has training resources that are available. They're free. They get updated from time to time, and they're interactive, and they check all the boxes. So it's a good way to do it. So now, the EEO policy has to include a link to the Department of Fair Employment and Housing, which is now the Civil Rights Department website for online training courses created by them. Companies' responsibilities just got to be reasonable, set policies, procedures, train, respond to complaints, investigate, take action, avoid retaliation, document. I'm going to say that probably a couple more times. Here's another slide just reviewing it. Supervisor, company is liable. Supervisor, harasser, supervisor's liable. Supervisor doesn't actually commit it, but just kind of knows it and doesn't do anything about it. Company liable, supervisor not. No action, just expensive. These cases can always spin out. You never know what you're going to uncover, what rock you're going to turn over. And, the company can be found in violation. And 2021, well, according to the EEOC, they paid out 62 million. Companies paid out 62 million for, say, sex-based harassment. And that's what these you kept track of. That's not necessarily everything that was paid out. Termination compliance, just real quick, kind of the flip side of hiring somebody. You just got to make sure you get, you have documents in place and procedures in place so that you're doing it correctly. One of the things we do is just take a step back, take a deep breath, and just think about it. Is this a reality check? Or is this really for a valid business purpose? Are you in compliance with that? There's more information on the slide. Termination meeting, be careful. Choose the time, choose the place, choose the circumstances, and decide what's the game plan going to be. Are they going to be asked to leave immediately? Or are you going to say, go back and clean out your desk? Generally may not be recommended. You may want to escort them out of the building. There could be, or out of your offices. There's lots of different ways to do this. And next slide, we're going to talk about, don't forget to give them their final paychecks. If you know you're going to fire them, to make sure you get their final paycheck on the way out the door. There are other things that we can talk about. Are you going to try to get a release? um, are you going to give out references? Be very careful about that. Have an authorization, date, time, confirm dates of employment, job, what the job title is. Keep documentation. Remember, I said documents are for you, for record keeping, for retention. Documents for us are evidence, so it's important. Final paychecks. This is important. Companies stumble on this. Either when an employee quits, either voluntarily or because you've terminated them, you need to make sure that they get paid for their wages timely. So if you know you're going to terminate somebody, you got to give them all the wages that are owed immediately at the time of termination. If it's the flip side, you don't know you're going to terminate them, something happens and it just is a fireable offense, or the employee announces without notice to you that, hey, look, I decided I'm going to quit, then you have to give them their final paycheck within 72 hours. And you generally have to pay them at the place of discharge. Some employers can just, negotiate that with employees. So what do you need to put in it? Make sure you pay them for everything they're owed at the time. That includes any bonuses, that includes commissions. If you pay vacation, then you have vested vacation and or PTO, make sure they get paid for that. And what can be deducted? This comes up all the time. You have to take out what's authorized by per pay period. So, for example, if you have loaned an employee money and they're paying you back out of every paycheck and there's a balance owed, you cannot offset their paycheck to recoup the money that you're owed. That's not permissible under California law. And if you get it wrong, the employee remedies are for unpaid wages, penalties, potential exposure under PAGA, which is a separate creature. Generally, bigger companies are worried about it, but as time goes by, we're seeing smaller companies get snagged by PAGA. Potential attorney's fees, individual manager liability. I already talked about PAGA. I won't talk about it again. Getting releases and waivers could be a good idea. Got to be really careful how you do it. If you're going to do it, get help to do it because you need to make sure it has a specific language that you need. There's a new law on prohibitions on no rehire. So you can't really have a provision in an agreement if you have an agreement that prevents employees from obtaining future employment with a company. So that's the devil's in the details. I'm not going to talk about that anymore today, but you just be mindful if you're going to do that. Then there are prohibitions. There's some certain things that you got to be aware of. If you're going to have a confidentiality provision, you got to be really aware of that because under the law, if you do have a confidentiality provision related to sexual harassment, sexual abuse, you're not going to be able to deduct either your attorney's fees or the amount you've paid in settlement as a business expense. So in this one, you really do need to go talk to a lawyer. ADA is the Older Worker Protection Act. That's if you have more than 15 employees. It's federal law. I'm not going to talk about it because I understand most of you are smaller than that. But if you are over 15, you want to have a written agreement. you need to be mindful that there's other requirements. So best practice on termination, have a strong at-will policy, got to do training. Some of this, what we've already talked about, company policies and procedures should be followed, be consistent, take performance reviews seriously if you give them, investigate before terminating, discipline without delay, and document alternatives, termination, time off, discipline, be aware of legal developments, seek legal advice when you need it. New laws that are here and on the horizon. And I know we've gone through a lot of this fast, but I wanted to leave time in case you have some questions. So new laws that are here and on the horizon. Well, some of them are here and some of them may be coming. COVID. COVID has not gone away. It's still here. In fact, recently the press has been announcing that there's been a surge. There's going to be a new vaccine available. This is way outside my pay grade to talk about, about COVID as a disease and as, and all of those types of issues. But what I can say to you is that we now have, as of very recently, some new regulations, non-emergency regulations. So COVID has now gone from pandemic to whatever the difference between pandemic and endemic is. Endemic, I think, is the word. It's now a fact of life. So workplaces have to be mindful of the requirements for doing the best they can to prevent the spread of COVID in their workplaces. So these are new things that are going to be in effect until for 2 years. The record-keeping obligations will remain longer. So the short story on this is if you have more than one employee, you're generally subject to this. There's some good things about it. There's some new things about it. But there used to be this thing called exclusion pay, where if somebody couldn't work because of work-related quarantine or isolation, company had to pay them for that. That has gone away. You're still required to report major outbreaks to the local public health agency. If you're a small company, it's the threshold for outbreaks is 20 or more employees, may not apply to you. Close contact has shifted around a little bit, but you need to be mindful of what those criteria are. Because close contact is with respect to whether or not someone needs to, isolate or quarantine. So you need to be mindful of that. And so depending on your workspace, this again, we did many webinars, sometimes with this organization with respect to COVID in the workplace since this started. So there's a lot of other requirements, but we just want to make you aware of it. You can go online to get more information to the Cal OSHA website. There's a link. Cal OSHA has terrific resources. They have terrific FAQs and forums, and they're very helpful on of assisting employers on these types of compliance issues. Bereavement leave is not a new concept, but what's new for this year is the requirement. Up until this year, companies could provide bereavement leave, but didn't have to. So now, if you have 5 or more employees, you do have to provide bereavement leave to eligible employees. So that means you would have to provide up to 5 days of bereavement leave to eligible employees when they experience the death of spouse, domestic partner, child, parent, parent-in-law, sibling, grandparent, or grandchild. This doesn't have a provision that we talked about, this concept of designated person. That hasn't made its way yet into this law. Stay tuned, it could. This leave can be unpaid. You don't have to pay employees for it. But an employee can choose to use accrued paid leave time. So if they have paid vacation or sick pay, they can choose to use that time. And you can request documentation to support the leave. It doesn't necessarily have to be a death certificate. It could be a notice. It could be something else. Some of this stuff is a little bit undefined in some ways. So use your common sense. And if someone's going through a tough time, they've suffered a family loss. You want to be mindful of that as with respect to whatever information you're asking for. California Family Rights Act. This is a huge change in the California Family Rights Act. Up until about 2 years ago, maybe a little bit longer now, that this law only applied if you had 50 or more employees. So a lot of companies that, this stuff really doesn't apply to me, I'm not going to worry about it. Well, lo and behold, the law changed, and it's now if you have 5 or more employees that you have to comply with these California Family Right Act uh, obligations. And so what that means generally is employees are entitled to a certain amount of leave. It doesn't have to be paid. It's unpaid leave, but for many small companies and even not so small companies, allowing employees to take 12 weeks leave can be significant for companies. But again, you need to be mindful that if an employee is qualified and eligible for this, then you need to be mindful that you have to provide it. And here we have a new category that's been added to this. And now we have this issue of designated person. So before it was, certain eligible family members, but now we've added yet again this concept of designated person with a serious health condition. And it's family members with a serious health condition too. So it's got to be a serious health condition. If it's for you, it's got to be a serious health condition. Designated person is someone with whom an employee has a blood or a family-like relationship. Do not ask me in the chat what family-like relationship means, because I won't be able to tell you, because right now we have zero law on this, and family law relationship means a lot of different things to a lot of different people. And the employee has to identify this designated person at the time to request leave. But the good news is at least they can only designate one person per 12-month period for purposes of this leave. So they can't take a leave, designate person A, and then a couple of months later go, okay, now I got person B. So no, one designation within a 12-month period. And then here's some new stuff that's coming down the pipe. Some of it's here, some of it's not. There's a Pregnant Worker Fairness Act of 2023, and then some new protected characteristics under state and local law, which some are sort of in effect now and some aren't. Hair discrimination, hairstyles and so forth. Menopause discrimination, that's a new one. I'll just say it that way. Don't know that it's been implemented yet, but it's certainly tied into other protected characteristics. Caste discrimination, that's different social statuses. That's something that's been a lot of talk about. Weight, height, and appearance discrimination has been kicking around for a long time. And again, these tie into a lot of other protected characteristics. So you need to be mindful of that. And then off-the-job cannabis use. That's a whole other subject. We've done other webinars on that. But basically off-duty cannabis use is not, not necessarily well, whether it's legal or not, it's not something the company can consider or should take into account. But if an employee shows up to work under the influence of alcohol, cannabis, or some other protected substance, or some other substance, then companies certainly do have rights to take actions to keep their workers safe and to keep their workplace safe. So that's what I'm going to say about that. Religious accommodation, there's new standards under federal law. Transgender policies and practices in the workplace. Affirmative action, DEI initiatives, we've been talking about that. There's, DEI is also a little bit of a minefield now. We just gave a webinar on that in my firm earlier today. But there's all this stuff is evolving as we go along. And then there's one other sort of final point that I'll make, which is there's a new law that just kicked in with respect to emergency conditions for employees leaving the workplace or being able to use their cell phones in the workplace. Many companies have strict policies, not so strict, but have policies that say, you can't just go ahead and leave the workplace unless you've got a legitimate reason, blah, blah, blah. So now there's a specific law that says you can't take or threaten adverse action against any employee because the employee refused to report or left the workplace uh, or within an area affected by an emergency condition because the employee thinks the workplace or work site is unsafe. And that's new for this year. Um, and it's a violation of the labor code. So this applies to even small companies. Um, and if there's an emergency condition, as defined and the definitions in the law, prohibits employees from preventing any employee from accessing an employee's mobile device or other communications device for seeking emergency assistance, assessing the safety of the situation, or communicating with a person to verify their safety. So in other words, if you have a no cell phone use in the workplace, your policy probably needs to be looked at because if there's an emergency condition, then you need to be mindful of that and being in compliance with the law. Why it's in the labor code, I don't know, instead of one of the other codes. But there it is. And same with, employees leaving workplace because of an emergency condition. They're in the labor code, so they apply even to small companies. And so with that, thank you. I know we've ripped through a lot of stuff. As I said, you'll get the slides afterwards. And I don't know if there are any questions or not, Matt.
There are a lot of questions. Thank you, Ed, so much. It's super informative for everyone. Kayla and I were chatting, so we look forward to your webinars because we learn a lot. Refreshers on employment law. There's so many new laws, and we really appreciate it. And as I mentioned, we had a lot of questions in the chat, and I'll get started. And I'll just preface it. The questions, as Ed mentioned in the beginning, this is a legal information webinar. So if there, some of the questions I've rephrased just a little bit, if they're too specific to your situation, those questions would be better suited in talking to an attorney during a one-on-one meeting. So if your specific questions aren't being answered today, or you have other questions, again, please reach out to Kayla and me to see if we can connect you with one of our attorneys during our upcoming event where we're connecting business owners with attorneys during our employment law or entity selection clinics. So please let us know. That said, we can get started on the questions. Lots of disclaimers, lots of lawyers that like to, make sure that we're being clear. Anyway, the first question is about handbooks. Way back early on in this webinar, you were talking about employee handbooks. And the question is it's pretty general, but how detailed does an employee handbook have to be? I know this is, employee handbooks are, big topic, but if you could just elaborate on that, that would be really helpful.
Sure. Yeah, I'm happy to. That's a great question because, as I say, one size doesn't fit all. But depending on the size of your company, you don't necessarily need to have a 80-page handbook. You have to have certain policies in place, including, as I mentioned, an EEO policy, a policy with respect to harassment, you want to have some policies with respect to your hours of business, your hours of operation, what hours a company is generally open. It makes a difference under California law for wage and hour law compliance. You may want to have policies with respect to overtime having to be pre-authorized, making sure employees know they should take their meal and their rest breaks. Um, and there may be some other things, but the point is you don't need, if you're a small company, if you have five employees, your handbook should include the policies that are a matter of law you're really required to have, and certain policies that impact your organization that you want employees to be mindful of. You may have other specific things that's important for your company that are not illegal that you want to talk about. Some companies, for example, will have a mission statement. Some companies will have what their expectations are. Some will have just general feel-good language, welcome to the company. So they come in a lot of different flavors and a lot of different varieties. One thing I'll add, you should have an at-will policy. That's something that would be mandatory to have in the policy, in my view. It's not required by law, but I think companies need to have that. So that's it in a nutshell. If you have paid vacation you give people, you want to have a paid vacation policy. If you provide sick pay, which are required to under the law, you want to define that policy because there are some choices that you may need to make with respect to are you going to give them an hour for every 30 hours work, or are you going to front load 3 days or 24 hours? So, so those are the types of things you'll want. But if you're a small company, you don't necessarily need to have policies that are going to apply only to large companies. And so I think that, oh, and you need to have, if you're 5 or more, you need to have a California Family Rights Act policy, which can be complicated. So those are, those are some of the things that we would recommend be in a handbook. And one final thing is you want to have an acknowledgement of receipt by the employee, so that the employee knows that they get confirmation that they've read it, they understand their responsibilities, and can ask you questions if they need to. So that's those really are kind of the basic elements. I may have forgotten an element or two, but since I'm doing this off the top, but hopefully that answers the question. So it gets you in the right direction.
Definitely. I mean, I think our clinic does help with reviewing handbooks, or if you have further questions on employee handbooks as applied specifically to your business, because there are, like Ed said, there are some specific policies you may want to add that are more individualized, and then we can also take a look at your handbook. If you're eligible for our services, that would be something we can help with. So thank you, Lily, for the questioning. Thank you for the acknowledgement of the response. The next question I think is pretty quick. Do you need to small businesses need to keep records of the 10-minute breaks? Like, how does the record keeping work for that? What are best practices?
Yeah, thank you. That's another really good question. The 10-minute breaks are always problematic for companies. Technically, well, different companies adopt different strategies. We've seen companies that have actually had people clock for their 10-minute breaks, but they're still on the clock. So they clock for their breaks to indicate that they've taken the break, but they actually are still on the clock. A lot of companies find that to be problematic because employees forget to clock in and clock out. Other employees keep things like, we have a sign-in sheet where you indicate whether or not you've taken your break for the day, and if not, why not, so that the company has a record of what's going on. There's electronic resources. If you have a payroll service, you can see if they can input that. These are features that are problematic for companies because employees often forget to do it. Meal and rest breaks, meal periods, people sort of got it by now. They know they have to clock for their meal breaks. Rest breaks are always more challenging. The other thing companies can sometimes do is to, with every paycheck, ask the employees to affirmatively state that they have taken all of their meal breaks and their rest breaks. That may or may not be effective if there's a claim brought downwind. Most of it is if you're in a, the most practical thing is make sure people know they're entitled. Make sure they should push away from their workstations, wherever that is, and get up and leave the workstation. They can leave, they go outside, they leave the company. But if whoever the supervisors are, whoever's in charge, just needs to make sure that you periodically reiterate to employees, you need to take them, and you're documenting if there's any issues and if employees are not taking them. So it's not a terrific answer. It's something that just continues to befuddle companies. You have to do something that works for your organization, that helps you to keep track of it, and have in place, again, if you have a handbook, or if not, even a policy that says what your expectations are, and make sure you reinforce that to employees. It's easy for me to say, but it is difficult. But yeah, so those are some suggestions I have.
Just one question I have for clarification. There's actually a few more questions related to breaks coming in the chat real time, but also I think that same question was asked. But when you say clock in and out, some of your the companies you advise, have people clock in and out for the break. That's just to track that they took the break, right? Because the breaks are paid. That's what we're talking about, right? The small 10-minute breaks.
Exactly. That's what I was saying, and that's why companies find it challenging. Because if you have a payroll provider and they're keeping track of all of this, they have to make sure that they don't treat it like a 30-minute break, which is the unpaid meal break. So as I said, it gets very problematic for companies to have enforce a policy where, or even a practice where employees are required to clock in and clock out for their 10-minute breaks, but still remain on the clock. So you're absolutely right, Matt.
Okay, cool. There's a bunch of other questions. One that came in, which was asked also in the private chat, is what happens if employees cannot or do not take breaks? Like, what is the risk related to that?
You owe the employee, thank you, that's a good question. The employee's owed 1 hour pay at their regular rate of pay, which can be more than their hourly rate if they get bonuses, commissions, overtime. But so they get paid 1 hour of pay as a penalty for not getting a meal break in a 24-hour period. They get another hour of pay if they miss one or more rest breaks in when I say 24-hour period, because generally a work day is from whatever time in the morning through basically through 23 hours and 59 minutes before you start a new work day. So if an employee misses, and if an employee gets 2 meal breaks a day because they work over 10 hours and they miss both meal breaks, they don't take them, then they get only 1 extra hour of pay. If they miss 2 or more rest breaks, they get only one hour of pay. The company also, for meal breaks in particular, has to be careful because of if they are not taking their breaks, then they are still working. So the company needs to pay them for the time they didn't take their break. And if if an employee is clocking out and still working, that's problematic because they should be taking their breaks. So that's it. It's 1 hour exposure. It's 1 hour regular pay. And if you're a big company, these stack up awfully fast. And there's other penalties that attach. There are PAGA penalties that attach. So that's beyond the scope of this, but there are a number of penalties that attach, and some of them are stacking penalties.
That makes sense. I think a lot of times when this comes up is people, you think you're getting breaks, or maybe didn't train your supervisors that well. And you as the owner are like, okay, things are fine. But then an employee leaves and says they got no breaks ever. And then, like you said, Ed, for a large company, that's a huge amount of liability that could happen. But for a small company, that could be a lot of your revenue. If one employee saying they never got a break for, hundreds of days could be a problem.
Exactly.
I was gonna, there's a follow-up question to this that I think is getting kind of specific. And I think I can help explain it too, but what happens if you just can't take breaks due to the nature of the work? I know for our organization, we have a lot of hourly employees that go out to events and represent our organization at events. And we always make sure to send 2 for the purpose of giving someone a break. Like, you almost have to have a relief built in. I don't think, and Ed, this is kind of a question I'm just curious about. I don't think an answer can be, yeah, the work is, something that requires someone to be on the clock straight, that's enough. I used to do some employment work, and we represented nurses, and they would have to bring in relief nurses just to break everyone out because of these rules. But is there any time, and we don't need to get into the specifics about type of work, because that might be something a one-on-one employment would be better for. But are there arguments, is it a good argument to say, like, well, this type of work, it's just really impossible to have people take breaks because it's so demanding during
Yeah, I mean, it's all facts and sort of great question and explanation, Matt. It's all facts and circumstances based. I would say this: most of the agencies and most of the courts are not going to buy an argument that it's impossible to give somebody a break. And by the way, companies have tried this over the years. Companies that are in manufacturing saying, "Hey, we can't shut down the machines." I mean, that's one common example that comes up all the time. So the machine's got to run. But to Matt's point, you need to have somebody come in and relieve that person so that the machine can do what the machine's doing. There are very few instances where, as far as impossible, if an employee misses a break and you're trying to justify it, then as the company, you have the burden of proof, and saying something is impossible, not practical, not economical, not unfair to me as a company. You are putting a really high bar that you are going to need to jump through. I have never seen a company be able to successfully do that. Um, because the law is the law. Employees are entitled to get their breaks. There's situations where it's beyond the scope of this, where in certain circumstances an employee can waive a break if they only work a certain number of hours. This is really beyond the scope of the question, but just to answer it, there are certain circumstances where if an employee doesn't work more than like a certain number of hours a day, more than 6 hours a day, or they work more than 5 but not more than 6, they can waive a break. That's problematic. A meal break, there's no similar law for rest breaks. If an employee is working and entitled to 2 meal breaks, there are circumstances where they can waive the second meal period if they've taken the first meal period. And then there's a thing called on-duty meal periods that you can use, and I mean, this is facts and circumstances, very, very specific situations where they get to take their meal period, but they're still on the clock, they're still getting paid, and it requires a separate agreement and very specific facts and circumstances. Somebody working in a gas station kiosk overnight. By the way, I don't say that would fly. I'm just saying that that's an example of, there's really nobody to relieve them. They're in there, they're going to bring their lunch to work. Those are very problematic on that. I mean, it really is facts and circumstances. And so those are just other things, but and I've already said impossibility is a high hurdle.
I can't even, I mean, you have so much more experience, but I can't think of anything that would be like an argument, like you said, that'd be impossible to give someone a break that would be okay with the courts. I think you addressed the new question that came in about, can a meal break be paid but still be on the clock? I think you said there's some facts and circumstances where that might be an okay policy. Whether or not that will still fly, there might be more reasonable circumstances, but that it's generally, the answer is no. But that is another question, Lily, that I think a one-on-one appointment or something would be good for, just to kind of understand the specific circumstances.
Yeah,
we have
agree.
one question still about breaks, Ed, and then we'll take a break from rest break question.
Break from breaks.
Waiting to say that. The last question about rest breaks is how often are breaks needed? I think this is a pretty straightforward question.
Yeah, I mean, look at the slide I gave you. For meal breaks, you can look at the slide. There are employees who work more than 5 hours are entitled to a 30-minute meal break. It needs to be taken by the end of the 5th hour of their employment, of their workday, or it can be a penalty. But look at the slide. The slide has all the information. Rest breaks, for every 4 hours worked or major fraction, which is 3.5 hours, that an employee needs to get a 10-minute break. It usually needs to be right in the middle of the shift, insofar as practicable. And that one's a little bit, but that can be vary based on business necessities. So every 4 hours, someone should be getting a short answers, or should be getting a 10-minute break. And if they work more than 8 hours, they work 10 hours or whatever, then yeah, they're gonna need to get additional 10-minute breaks. and perhaps an additional 30-minute meal break. But the slide actually has the information. I'm sorry, I just ripped through that pretty fast. So when you get the slide presentation, I think you'll be able to see it pretty easily. And by the way, the Division of Labor Standards Enforcement for California has really good resources too, where they have, they have tools to, I think they have tools to help companies stay in compliance.
Yeah, I've seen them. They definitely do. But I remember the slide. It's really good. And the follow-up, this all applies to, there's some laws that only apply to larger businesses, but breaks and everything apply to even if you have just one employee. Is that right? Yeah.
Exactly.
Yeah,
all the labor laws apply. California labor laws apply if you have one employee. And that's in the labor code. So that one applies. And I mentioned it in passing, but you're also required to post in your workplace I mentioned it in passing, but wage orders for your specific business or occupation. So you can go to the DLSE website, and you can get information on what wage orders need to be posted in your workplace. And wage orders actually have all of the requirements for meal and rest breaks and overtime and lots of other stuff. And that should be posted in your workplace. You can download it from the website, or you can buy one, or that's already, or actually they give you one. You can get it, but there's but you need to have that posted in the workplace, and that has all the requirements for what we've been talking about today with respect to meal and rest breaks and overtime and so forth.
Okay. Wading through this, we have just a couple more questions.
Okay. Oh, one more thing about that, the wage order. I'm sorry, Matt. The one more thing about it is it also helps you identify what business or occupation that you have. And so you can help, there's tools on there to help figure out which wage order you need to post, because there's a bunch of them. Okay, next.
Let's see. I feel like this is the most questions we've ever had for a webinar, which is great. I mean, it means that everyone's very attentive, so we appreciate that. The next question, I think, is when you were talking about unpaid internships, Ed, I'm glad you talked about that because we've heard that a lot. There was a question relating to what happens if you're connected to, and I'm not sure if you covered this, but like if you're getting interns from a college or a high school, and we'll just assume, because this opens up, I know a lot of laws if they're younger kids, but let's say they're 18-year-olds and getting school credit. How does that work? Is that?
Yeah, that's a whole other story. I mean, I really can't go through all of those elements other than to say, sign up for one of ICLS's, one-on-ones, because that's an incredibly problematic area. And I'm not punning on it exactly, but it is but it's the facts and circumstances, it's a detailed inquiry. And I know there's a big push to get people into these internships. I know it's out there because these questions come up, but they can be very complicated. And the difference between an internship and whether the educational institution that's saying bring our people in as interns, they should be able to help in providing assistance with respect to making sure that these people are properly classified as interns. If they're just throwing them in and saying, hey, look, they're interns and this is what it is, they'll get school credit or whatever it is, that's fine, but you just need to be really careful. That's why I mention it. I mean, it's just, we can't get into it any more specifically. And that's different than a work permit. If you're a younger worker and you need to get a work permit, to the extent they're still required, that's a whole different inquiry, because students can also get work credit. But work permit is not the same as an internship. And the law can be pretty strict that people who do these jobs are entitled to be paid for it. And there's that whole dichotomy between is it for the benefit of the company or for the educational benefit of the employee. So that's all I can say about it at this point.
That's great. Thank you. And we love the plug to the clinic because that is something that we can help you go over with your specific information. The next question is, um, it came from the chat. I'm curious about part-time employees. About how many hours per day would be standard minimum for part-time employees? And I think this probably depends on your business. I don't think there's any law saying part-time employees generally work X amount of hours, but I'm wondering if you have anything to add to that, Ed.
Yeah, no, I'm not aware of any specific thing saying what's a part-time worker versus what's a, what's a full-time worker. If you're a big enough company, sometimes that's determined by whether or not an employee is eligible for certain benefits, whether they're eligible for a company-sponsored health plan, for example, because the health plan may have a minimum hourly requirement that employees have to work. It could be 32, it could be 34 a week, but there's generally a requirement that has to be satisfied before they're eligible for the company's health insurance. And a company can define in its handbook or some other document what it considers to be full-time and part-time. Full-time, we know, is generally considered 40 hours. Part-time, can be something less than that. And companies will try to set part-time hours so that an employee may be entitled to a 10-minute break, but they don't necessarily get a 30-minute unpaid meal break. So they'll be scheduled for 4-hour shifts, for example. So yeah, that's my general. And if there's other, if you have other benefits, you can make them available depending on whether an employee is classified as part-time, full-time. And that's for the company to define.
Thank you. I think it shows that a lot of these things are really for the company to figure out based on their needs. We have 2 questions. I don't think either are too long. I know we're getting near the time, but the next question is contractors, for independent contractors like cleaning crews. Do we still have to worry about federal law also? I know there's a lot of talk about California law of independent contractors. I think this answer is probably kind of outside the scope of this whole presentation, but fundamentally there are federal laws that define what independent contractors are as well.
Yeah, independent contractors are that's a great question. It's a really slippery slope. I mean, it depends on who the administration is federally, because there are, you're absolutely right, there are rules on independent contractor. Typically, California law, I believe, is still stricter than federal law, and federal laws maybe in more of a state of flux than California law is. So again, remember, you have to comply with what's most protective for employees and whether or not it's a bona fide independent contractor relationship. There's many, many tests for determining independent contractor. The ABC test, there's every agency has a different one. Workers' compensation has a different test. The state taxing authorities have a different test when they're trying to collect employment taxes that aren't paid. The IRS has a different test traditionally. The Department of Labor is messing around with what the test of the day is. I shouldn't say it that way, but there seems to be more of a state of flux when the administration changes on the federal side. The independent contractor law has been beefed up here in California over the last few years pretty dramatically.
This is definitely an area that if you have specific questions about your business or what type of person you want to bring on as an independent contractor and the rules and all that for your company, an independent contractor might be okay for one company, but not for your company because all of those facts take into consideration.
Yeah.
But you should reach out to us and we can help you out.
Yeah, and the main thing on independent contractors, the company thinks they're out, get out of the overtime, the meal and rest break stuff, but they really do have to be independent. Independent contractors, no joke. They have to be free from direction and control of the employer. Janitorial services, that was mentioned in the question. I'm not going to comment on those specifically, but generally, if you're bringing in an outside vendor to do stuff that's not in your wheelhouse, and you make sure they are licensed by the state, by their local, whatever it is, whatever their licensing is, that's required. It could be city or county, depending on where you are. That they have workers' compensation insurance, that they're a bona fide legitimate company, meaning that they're a corporation, an LLC, a limited partnership. Corporation is, and limited liability companies are, or partnerships. Like I said, there's different layers of business, but they gotta, it's got to look like a duck and quack like a duck to be considered to be a duck. So if it's truly an independent company, they ought to be able to provide assurances to whoever's hiring them that they are, in fact, a bona fide company, and they are doing things and providing appropriate indemnification language for companies who engage them.
The last question, I think this one actually is relatively quick. If an employer gives their employee vacation time, but they're closed for business, like for a holiday or something, does that count as vacation time? Or is that a tricky question? There's a lot of things where you're like, this is going to be easy, and then I see it and you're like, this is something that
it's a trick question. It really does kind of depend, and this is the devil's in the detail on how the company sets it up, because and it may depend whether they're exempt or non-exempt. But that's a great question. And the answer is it's just going to depend. If it's a factory shutdown and you have non-exempt employees, then that's you could have a policy that says they're allowed to use accrued vacation if they want to, or it's unpaid. This really depends on the facts and circumstances. It's a great question. Traditionally, some companies do shut down for a week or two over certain holidays. We see that in the manufacturing industry a lot. Not a lot anymore, but we used to see it more in the aerospace industry. So it involves a really specific inquiry as to how it's going to be classified and how it's going to be characterized.
Thank you. That is all of the questions we have. Ed, I can't thank you enough for doing this and hanging around a few extra minutes to answering all our questions. I'll just say thank you. We really appreciate your time. Ed, if you have any other concluding remarks, we'd love to hear them.
Nope, I am all talked out. Thank you all for hanging in there and paying attention and asking great questions. We appreciate it.
Well, thank you all. We will send the recording and the slides out to everyone. And again, please email us. You have me and Kayla's email addresses. You'll get it again, but please email us if you have further questions or want to apply to attend one of our one-on-one meetings. Again, thank you all. Hope you all have a great week.